appeal in the matter of Line PTE Ltd and Priminds Shipping HK Co Ltd.
Just if you will give me a second, just to get myself sorted out. Right, Mr. Hancock.
Please, Your Lordships. As Your Lordships know, I appear in this matter together with Mr. Alex Wright on behalf of the appellant charterers and my learned friends Mr. Simon Rainey, Queen's Counsel, and Mr. Tom Bird appear on behalf of the respondent owners, and I will refer to the parties as charterers and owners respectively. I hope that Your Lordships should have received skeletons from both parties, and in addition I hope that Your Lordship should have received two files of authorities together with a few extra authorities that have come in over the course of essentially last night and this morning. We will have in due course copies of the hard copies of those authorities which I hope will
Right. Well, so far as I'm concerned, Mr. Hancock, anything you want me to look at will have to be sent electronically.
Right.
Yep.
I'm grateful. The appeal, as Your Lordships know, is against the decision of Mr. Justice Andrew Baker. The point is a short point, but an important one in the shipping community, and essentially is whether unliquidated damages are recoverable in addition to demurrage by reason of a detention of the vessel, where the only breach was a detention of the vessel. In the particular case, then the unliquidated damages claimed constitute a cargo claim made against the owners of the ship, which was settled by the owners, and the various assumed facts are set out in the judgment and in our skeleton. Most importantly, that the owners were not at fault or assumed not to have been at fault, and that the settlement of the claim is assumed to have been a reasonable settlement. In most cases, then those assumptions will be subject to strenuous challenge, but that's not the case for the purposes of the preliminary issue that was before the judge and is before Your Lordships. The relevant clause is set out in paragraph 11 of our skeleton, and although in the respondent's skeleton from time to time it is suggested that the word demurrage may have different meanings in different contexts, then I would submit that it is in fact a well-recognised term with a well-recognised meaning. And we would, for example, submit that it would be very surprising if the answer to the question before this court were to differ as between the tanker trade as opposed to the dry bulk trade, as is suggested in, for example...
We've got a bit of competition outside, Mr. Hancock, so if you could speak up a bit.
I will try, my lord, yes.
You seem to have a little habit of dropping your voice, and if you do that, we won't get what you're saying. You're saying demurrage is well recognised, and it would be strange if it were to be construed differently in the tank trade and the...
And the dry bulk trade, my lord.
Yes.
The well-recognised meaning of demurrage was most clearly expressed by Lord Brandon in a case called the Lips, and that is at Authorities Bundle tab 21, which is the first Authorities Bundle. find the relevant quotation at page 299 of the bundle.
Which tab is it?
It is at tab 21, my lord.
Yeah.
And it's the sideline passage beginning at letter E on page 422 of the report, page 299 of the bundle. Lord Brandon said, "It is essential to the decision of that question to have in mind the legal nature of demurrage, both what it is and what it is not. I deal first with what demurrage is not. It is not money payable by a charterer as the consideration for the exercise by him of a right to detain a chartered ship beyond the stipulated lay days. If demurrage were that, it would be a liability standing in debt. I deal next with what demurrage is. It is a liability in damages to which a charterer becomes subject because by detaining the chartered ship beyond the stipulated lay days, he is in breach of his contract. Most, if not all, voyage charters contain a demurrage clause which prescribes a daily rate at which the damages for such detention are to be quantified. The effect of such clause is to liquidate the damages payable. It does not alter the nature of the charterer's liability, which is and remains a liability for damages, albeit liquidated damages." Then, my lords, a demurrage provision is a liquidated damages provision in respect of the detention of a ship beyond the specified lay days. Our starting point is therefore that, given that a demurrage clause is a liquidated damages clause, it should be treated in the same way as is any other liquidated damages clause in other areas of the law. And we have collected in our skeleton, in paragraphs 17 to 28, various of those authorities, principally in the field of construction law, but your lordship will be familiar with liquidated damages clauses in other areas of the law.
I mean, just explain to me, Mr. Hancock, why it should be treated the same way as any other area of the law. I mean, the question for us is the construction of the clause. The clause is drafted in such a way that it's pretty unhelpful, and all it tells you is that if you understand demurrage, you know what this clause is saying. So the critical question in this case seems to me the meaning of demurrage. Now, demurrage might be a liquidated damages clause covering all types of loss caused by the failure to unload the vessel, or it might not. But it rather begs the question to say it should be construed in the same way as other liquidated damages clause.
My lord, with respect, what I would submit is that one has to ask what the purpose of a liquidated damages clause is. And the purpose of a liquidated damages clause is the same in each area of the law. It is to bring certainty and to avoid the need for controversy in relation to the assessment of damages. Both parties know actually what their exposure is if a breach of the relevant character takes place.
Yet you're pushing at an open door. Of course, a liquidated damages clause, properly so called, avoids difficulty and litigation, and the judge's judgment doesn't. But that may not be conclusive if the meaning of demurrage were as the judge said it was.
That's right, my lord, but one that does then have to test the question of whether there is a good reason for demurrage to be treated in a different way from any other form of liquidated damages clause.
But is it about good reasons, or is it about the understanding of the meaning of the word in the market over centuries?
Well, I would say that it's both, my lord, and it's when one goes to the meaning of the word in the market, it's not a question of the meaning of the word in the market over centuries, because what is clear is that the meaning of the word in the market that has been identified by the respondents is a meaning that has been discredited in more recent times. And that began with the case of Reader and Arcos, to which I'll be taking your lordships. In the early days, then the position was that demurrage was indeed treated as a debt claim. It was treated as a sum which was payable by the charterer for the detention of the vessel, but it was treated, and the most famous example of this is the dictum of Lord Trainer in Lilly against Stevenson. It was treated as a situation in which the days on demurrage were essentially lay days for which payment had to be made. That is a treatment of demurrage which in the modern world has been said to be clearly wrong.
Well, that he says so in lips.
He says so in the lips, indeed, my lord. And when we look at the textbooks, for example, Scrutton, on which reliance is placed, Scrutton again specifically says that that view of demurrage as being, if you like, rent payable for keeping the vessel beyond the lay days is not one which appertains in the modern world.
I mean, that point was clearly decided, at least one point was clearly decided in Rydar and Arcos itself, so I suppose any fixed view as to the meaning of demurrage would have to date from no earlier than that.
Indeed.
Okay, I take back centuries. A century.
A century, my lord, yes.
This jurisdiction has been very active in the shipping market over that century, so there must be a lot of it.
It has, my lord, and there's never been a case like this one before. So,
That's
for the
always
past
intimidating for the court, Mr. Hancock, yes.
for the past 100 years, then it hasn't been thought that the regime whereby, or which was established by Reader and Arcos, to which I'll take your lordships, whereby you have to establish a separate breach in order to be able to recover a separate loss, was unsatisfactory. That was...
you call that a regime?
My lord, yes. I call it a risk allocation regime, which the market was happy with.
Okay, well, you're going to have to unpack that a bit.
Yes? Maybe easier if I do so after I take your lordship through some of the authorities.
I just want to say something about the authorities.
Yes.
Some of us anyway, have looked at some of these authorities. And they, what should we say, they're a bit mixed, aren't they?
Yes.
And the question we are actually deciding is undecided, apart from by the bond. And we're not bound by the bond.
Yeah.
And so what I'm urging is, we've only got a day for this case.
Yes.
We understand how important it is and the ramifications of it. And what we perhaps don't want to do is to get into the intricacies of Swiss Atlantique when we know that the outcome is, as it always was when I was at university with Swiss Atlantique, a lemon. And it's not conclusive of anything, let alone this point. But obviously you will take your own course in this and show us what you think we need to see.
Yes.
But ultimately I am reasonably clear in my mind that we need to understand why demurrage, since Arcos, is to be understood in the way you say and not the way they say. And so far as authorities bear on that, great. So far as they don't, not great.
I follow, my lord. The difficulty is that it's the lack of authority that essentially bears on that question. And that's why I say that this case is novel in the sense that nobody had actually suggested that the approach to demurrage that I am suggesting as the settled approach was not the settled approach, certainly for the last 30 years, since the Bondi.
Well, I mean, you say that, but I mean, it's a settled approach for the last 30 years since the Bondi, except that the leading textbooks on the subject said the Bondi was wrong.
Well, that's not quite right.
I'm paraphrasing.
Well, then,
might be wrong. So the market did not know that the point was settled. In fact, the market for the last 30 years has obviously been waiting with bated breath for this case.
my lord, I would submit with respect that the market wasn't actually looking at additions and footnotes in Scrutton and changes in additions and footnotes in Scrutton, and certainly wasn't looking at articles by Mr. Gay in the Lloyd's Commercial and Maritime Law Quarterly. What the market was looking at was the decision in the Bondi, which at that stage was thought to determine this issue with finality.
Were standard demurrage clauses changed in response to the Bondi? Is it the Bondi or the bond? My lord told me earlier it was the bond.
I can't answer that question, my lord. I'd always refer to it as the Bondi.
Might be the
I've
most
always referred to it as the bond. So
Oh yeah, so we don't worry
Lordships
about
will
it.
have to resolve that dispute as well.
Yeah, but I mean, the question about whether market clauses changed in response to the bond is
My understanding is no, they didn't.
no evidence. No
That's my
evidence they
understanding,
did.
but no evidence.
Was there any evidence in this case?
No. Not as far as I know. No.
Okay.
That might be one of the reasons why Section 45 perhaps wasn't such a great idea in this case after all, but it's too late for that now.
That's true, my lord. And indeed, there's been at least one academic commentator who's complained about the fact that there were all sorts of issues that weren't decided or addressed because of the fact that it was a Section 45, because issues of remoteness and causation and the like weren't in issue.
Yes.
But the view of some arbitrators would have been helpful to tell us about market understanding and
Yes.
practice and so forth.
Although, as your lordships know, you do have the view of some arbitrators because there are some maritime decisions in the bundles.
But it's very difficult for an appellate court to deal with that kind of approach to expert opinion.
Yes.
I mean, you know, I'm sure everybody in this case has tried very hard to put everything before us that they've been able to find, but actually putting ourselves in the position of market operators is very difficult.
Yes. I understand that, my lord.
Yeah. Okay. Well, there you go.
Well, what I was going to take you to next is I was going to take you to the short passage from McGregor on damages, which is in fact cited by the respondents in relation to the question of whether, in fact, calling the clause the liquidated damages clause is indeed to beg the question. And that's in volume 2 of the authorities bundles. And it's at tab 52. This is the discussion in McGregor of liquidated damages generally. They make the point that I've already made, which your lordship has accepted, namely that liquidated damages bring certainty and avoid costly litigation.
Oh yes.
And then they go on to say that, however, the claimant will be entitled to sue for unliquidated damages in addition to suing for liquidated damages.
So where are you reading? Oh,
16024, my lord.
Yeah, thank you.
If other breaches have occurred outside those which fall within the ambit of the liquidated damages provision, or it seems if only part of the loss arising from a single breach is regarded as falling within the provision's ambit. The position is illustrated by Reader and Argos, and they set out the facts of that case, and then they go on to cite the Altus, a decision of Mr. Justice Webster, and the Altus was not in fact a demurrage case as such, it was a dead freight case. The position there was the charterers had not loaded a full and complete cargo, and the result of less cargo having been loaded than should have been was that a different demurrage rate was applicable. And so the question in front of Mr. Justice Webster was the dead freight clause a liquidated damages clause? And if it was a liquidated damages clause, could the further loss in respect of the superadded loss demurrage due to the reduced quantity having been loaded be recovered? And Mr. Justice Webster held firstly that it wasn't a liquidated damages clause, the dead freight clause, and secondly that even if it was, then the superadded loss could be recovered. But we'll need to look at why he held that, because in my submission, as indeed the judge indicated, that judgment is not a satisfactory judgment, but it is nevertheless one of the judgments that is relied upon by the editors of Scrutton in relation to the footnote, changed footnote, that your Lordship has referred to already. So, McGregor bases itself for the proposition that the respondents derive, which is the same proposition put forward by the judge, namely that the relevant provision may provide only liquidated damages in respect of one particular type of loss, as opposed to liquidated damages in relation to all loss.
Well, of course it may.
Well, it may.
If it says so.
If it says so. And your Lordship's quite right. The question is, does this clause say so? My answer to that would be clearly not in terms, which then means one goes back to your Lordship's further point. Well, what would a reasonable reader in the position of the owner and charterer read into a clause which simply stated that demurrage was recoverable for a detention of the vessel beyond the lay days at a specified rate? Would a reasonable reader assume that that meant that all you could recover for detention of the vessel was demurrage at the specified rate? Or would a reasonable reader assume that what was being said was that you could recover that specified rate plus unliquidated damages in respect of an uncategorized type of losses falling out with the demurrage provision, which uncategorized type of losses is extremely difficult to define, as we'll see when we look at some of the, in particular, Mr. Gay's article, in which he tries to satisfactorily define what should come with.
I mean, you say the line is so uncertain as to make this a totally unworkable decision.
Right.
And it'll throw the market into chaos.
Right.
So they have to be careful what they wish for.
Quite so.
I mean, I've been spending my time thinking of examples of what would be covered and what wouldn't be covered. And I've thought of quite a few that where the answer is probably covered by Swiss Atlantique, i.e. very difficult.
Yes. Well, take a few examples, my lord. Bottom fouling.
Yes.
Extra use of diesel oil in port. Extra port dues due to prolonged stay in port.
Damage from I suggested damage from a tornado that struck the port, but nowhere else.
Yes. Although, again, once again, there would be other provisions within the Charter Party that might be expected to deal with that type of event, viz. The safe berth, safe port or safe berth warranty, which, as in most voyage Charter Parties, is to be found in this Charter Party. Indeed, actually, there are situations in which the characteristics of the port or berth may extend to the making of cargo claims within that port. So, for example, if it is a characteristic of the port that stevedores are in the habit of taking a share of the cargo, that will render the port unsafe. That is catered for by the Safe Port warranty. You don't need to look for anything down to the detention of the vessel in that regard.
I mean, other provisions may or may not help on the fact. So your Safe Port example might provide you with an answer, or it may be that the port would have been safe if the vessel had got in and out within the time that she was supposed to, if the discharging had been completed either within the laytime or even within a short, non-frustrating time after expiry of the laytime. So,
yes.
So the other provisions won't necessarily give the answer to, for example, my Lord's example.
They won't necessarily, but they will actually, if you like, reduce the ambit of the example. So if the position is that when the vessel is sent to the particular port, then it is foreseeable that delays at that port will be extreme, that will involve a breach of the Safe Port warranty. But your Lordship is quite right in saying that that won't necessarily be the case, and it remains therefore a possibility that there may be situations which are not catered for by other terms of the Charter Party, which would then have to, as it were, fit within what remains. The question, though, which is at the root of this case is, well, who takes that risk? Who takes the risk of that type of event? Is it the charterer or is it the owner? Because a demurrage clause, like any other provision of this sort, is a risk allocation clause. So the parties know where they stand. And as my Lord the Master's Rolls has already put it to me, then the difficulty that one has with the learned judge's judgment is very difficult to know where one stands, given the vagaries of the types of case that one would then be dealing with. Whereas at least with a liquidated damages clause, which liquidate all loss flowing from detention of the vessel, both parties know where they stand.
I'm also struck by the difference of expression that judges have adopted when describing what demurrage caters for, because many of the judges say, well, it caters for a cost arising from the delay of the vessel, costs arising from failure to be able to use the vessel, failure to make profit from further voyages, and so on. I mean, there's all sorts of formulations, but they tend to be very much directed to the facts of their case, which you have to be careful about.
Yes, and I think it would be fair to say that the principal loss that would be anticipated as the result of detention of the vessel is always going to be the loss of potential profitable earnings on a subsequent fixture. That's the principal area of loss. Indeed, Swiss Atlantique itself is a perfect example of that type of situation, because as your lordships know, in Swiss Atlantique the argument by reference to Reader and Arcos was that in Swiss Atlantique the detention, it was said, led to a further distinct loss, viz. The loss of further voyages within the contract of affreightment period. And that argument was rejected on the basis that that wasn't a distinct loss in the same way as it had been. It wasn't caused by a distinct breach in the same way as it had been in Reader and Arcos. It's just as McAtter said, well, in Reader and Arcos, the extra loss, the loss of the superadded freight, occurred on the very same voyage that the detention occurred, whereas in Swiss Atlantique, then the detention in voyages 1 to 7 led to the loss of profitable potential further employment on voyages 8 and 9, which couldn't be performed because voyages 1 to 7 took too long.
Swiss Atlantique was the same kind of loss case, regardless of whether it was one breach or, as the charterers unsuccessfully argued, a two breach case.
It was the same type of loss, but in both the Court of Appeal in particular and in the House of Lords, then the judges concentrated on the fact that it was a one breach case, not a two breach case. So Mr. Justice Harman, Lord Justice Harman and Lord Justice Sellers in particular in the Court of Appeal, and Viscount Dillon and Lord Upjohn in the House of Lords, both talk in terms of the inability of the claimant in that case to show a different breach. So in a sense, Swiss Atlantique was both. They couldn't show a different breach and they couldn't show a different sort of loss. What they were trying to do is they were trying to show a different sort of loss. But that argument was rejected. But it was rejected by the Court of Appeal and the House of Lords principally on the basis that they couldn't show a different breach other than detention. So in my submission then, Swiss Atlantique does actually provide support for charterers' position. And one of the peculiarities actually about that is, and your lordships will see this when you see the bits from Scrutton, is Scrutton, as the learned judge pointed out, when the editorship of Scrutton changed in 1996, the references to Reader and Arcos also changed. And for the first time it was suggested that where you had a further loss arising from the same breach, that might be recoverable. And the editors of Scrutton, for that proposition, put reliance upon the Adelpha, which was the obiter dicta of Mr. Justice Evans. They relied upon the Altus, which is the Mr. Justice Webster case. They relied upon the speeches of Lord Justice Banks and Lord Justice Atkin, essentially on the footing that those two judges agreed with one another in Reader and Arcos, which I would submit clearly is not right, and indeed the judge accepted was not right. And the editors of Scrutton then effectively say CF, which as I understand it means compare and contrast, Swiss Atlantique and Richco and Töpfer, which is the bond.
CF, means compare, really. Yeah. I don't think it means this is the per contra.
No, it's certainly not per contra.
No.
But it's not C, as it were. So it's not actually saying these cases also support the proposition.
I don't think we're going to decide this case on the basis of whether Scrutton uses CF or C.
No.
Or per contra.
All I was saying, my lord, is that
you do seem to know the note in Scrutton quite clearly, Mr.
I do. That's just because I looked at it this morning again.
Yes.
But,
it's strange if a case is to be decided on something like that, and that there is no clearer understanding of the meaning of a term that has been used in shipping for so long.
Well, my lords, it would be strange if a case like this was going to be decided on the views of textbook writers which vary between themselves, notwithstanding the fact they're relying on exactly the same cases. So,
yes, although we do know the cases don't help much either.
no, although perhaps what I would submit is the clearest example. It is the views of the editors of Carver in 2017, which the judge did refer to, and learned editors of Carver said that the position was settled in the light of the bond.
I mean, that's just a comment.
Well,
I mean, everybody knows that a first instance decision does not settle the matter if somebody chooses to take it to the Court of Appeal.
no, but what it does indicate is that practitioners in the industry and distinguished practitioners in the industry understood that case to settle this particular issue. In addition, I might add that Mr. Gaunt, in his book on shipbuilding contracts, who's the past president of the London Maritime Arbitrators Association, also regarded that as the position.
I think the editors of Carver in their second edition say it's now rather unsettled.
The editors in their second edition say that perhaps it wasn't open to Mr. Justice Baker to take the course that he did, but and as your Lordship rightly says, now it is unsettled. So it's going to be a matter for this court to decide whether Mr. Justice Baker was right to depart in the way that he did from the case by reference to which, my submission, the trade had been directing itself for a period of 25 to 30 years without any demur. So, well, perhaps I should now turn to Reader and Arcos itself. Though just before I do, there is one other point I would make on both a general point, and that is that whereas here, in my submission, the parties have chosen a risk allocation, they will also take steps to lay off the risks that they themselves have undertaken. And most obviously, they will take out insurance in respect of that risk. And in this regard, as far as cargo claims are concerned, then owners have P&I insurance to cover them in respect of those cargo claims. In certain other contexts, not very often the voyage charter context, but in the time charter context, then quite often the owners and charterers, indeed usually, owners and charterers agree a specific allocation of risk in the interclub agreement. So again, it's not something that the parties are not alive to. And as things stand, the party who would normally be concerned with cargo claims is the ship owner and the ship owners P&I club. So all that is happening here is by virtue of the change in the perceived allocation of risk. One insurer is now actually going to be pursuing either the charterer or more probably another insurer, viz. The charterer's insurer.
Well, it was ever thus.
It was ever thus, but again, the only parties that benefit from that are the lawyers rather than the parties themselves. Hence the desirability of having clear allocations of risk of the sort that in commercial law generally are always what parties wish to achieve.
The certainty of the common law, and particularly of commercial law, is, to my mind, of great importance. So you're pushing at an open door there. However, I think the other side would say this is the correct outcome.
Yes.
Their outcome is the correct outcome. So, may cut both ways.
Wait a moment.
Anyway, here, reader and Arcos.
Reader and Arcos, my lords. So, your lordships will find that in the first authorities bundle. And that is tab.
Well, it's tab 5.
Tab 5 is first instance. Let me start with Mr. Justice Greer's judgment. And if I can just start at page 33 of the bundle, very briefly, just looking at the submission that was made by counsel Sir Robert Cass. This is just underneath the new date of Friday, April the 23rd, 1926. You see, Sir Robert Cass, continuing, said that the facts were not in dispute, and he submitted that there were two obligations on the charterers: to load a full and complete cargo, and to load a cargo at a defined rate, which they had not fulfilled. So that was his submission, that there were two separate obligations, neither of which had been fulfilled.
It looks as if overnight he thought better of the answer that he'd given last thing on the previous day, where he only referred to one breach. But you're right that he does settle on two in the end.
Yes. And your lordship will have seen as well that when we get to Mr. Justice Greer's judgment, he talks in terms of primary obligations, and being the primary obligation to load a full and complete cargo, not in the photo production sense. In his judgment at page 34, in the sideline passage, he says, what are the obligations of the charterer? He has, as the plaintiff's counsel has argued, two duties to perform in relation to the loading of the cargo. One is that he has to load a full and complete cargo, and the second is that he has to load the agreed rate. What is the meaning of a full and complete cargo? In my judgment, it means that which would be a full and complete cargo if the charterer complied with his obligation to load at an agreed rate. That means that it would, in this case, have been a complete summer cargo and would have consisted of, I think, 850 standards. It is said that all that happened in this case was that there was a delay in loading, and that the contract has completely provided for the amount that is to be paid by the charterer for that delay in loading. And attention is called to the provision about the £25 per day. In my judgment, although I've had some hesitation about it during the course of the argument, Sir Robert Aske is right in saying that merely provides damages due to the detention of the ship, so much per day for the detention of the ship, but that does not prevent the plaintiff shipowner from saying, in a case where there has been detention of the ship, that he is also entitled to say that there has been a breach of the primary obligation to provide a full and complete cargo. As I say, a full and complete cargo, in my judgment, means that which would be a full and complete cargo for the vessel if loaded in accordance with the terms of the charter party. For these reasons, I think the plaintiffs are right in their contention and are entitled to recover the amount which they seek to recover for dead freight. So his judgment, quite clear: two breaches, one breach leading to the failure to load the full and complete cargo, i.e. the summer cargo, the second breach being the failure to load in due time, leading to demurrage. Then if we go to the next tab, which is the Court of Appeal decision, Then the argument is again at page 39 of the bundle. And it's the same argument. The obligation of the appellants was twofold. First, to load a full cargo. Secondly, to load that cargo within the lay days. And then below that, their second obligation was to load in a fixed number of lay days, or the equivalent of a fixed number, for breach of this obligation, but not for the breach of the obligation to load a full cargo. The damages are agreed by clause 3 of the charter party at £25 a day. Then we go over to judgments, and firstly the judgment of Lord Justice Banks. And he says that the action was brought by ship owners against charterers for damages for breach of a charter party. The breach alleged was a failure to load a full and complete cargo. Mr. Justice Greer decided in the plaintiff's favour, and he founded his decision upon the view that what constituted a full and complete cargo must be ascertained by reference to those stipulations of the charter party which provided for the rate at which the charter is undertaken to load. For the reason which I refer to later, the plaintiff's claim, if any, must, I think, be based upon a breach of the stipulations as to the rate of loading, and the case thus presented raises the two important questions: whether, having regard to the terms of the charter, there was any breach on the part of the charterers, and if there was, then whether the breach is satisfied by a payment of demurrage at the stipulated rate. Then he goes on at page 44, and after referring to the Ethel Radcliffe case and the case of Lillian Stevenson, then he holds at 44, about a third of the way down the page, that by failing to load within the lay days, charterers commit a breach of contract. So that, going back to the point that my Lord Justice Mayles raised earlier on, that was a point on which all three of their lordships agreed, that demurrage was, or gave rise to, liquidated damages for a breach of contract. Then actually...
It might be just worth noting also that the reason why he held it, that the only breach was the failure to load within the lay days, was that he took a different view of the meaning of full and complete cargo, which we see at the top of...
He did. He effectively held that a full and complete cargo was the amount that could be loaded, yes, as at the time that the ship completed loading.
Yes. So for him, there was no breach of that obligation.
Yes. And on that, then, he was quite clearly in the minority, yes, and I would submit he was, with great respect, wrong, and the majority were correct. And then he went over at page 45 of the bundle, then to say the only question which remains for decision, therefore, is the question of damages. If the plaintiff's claim was in substance, though not in form, a claim for detention of the vessel, the special damage here claimed for would not be recoverable, invocate and bungie. On the special facts of this case, the plaintiff's claim appears to me to be, both in substance and in form, essentially different from any claim for the detention of the vessel. In substance, what the plaintiffs are saying is that if the charterers had loaded the goods at the agreed rate, they would have earned freight on 850 standards. Whereas, owing to the failure to load at that rate, they could only earn freight on 544 standards, and that their loss, directly flowing from the breach of contract, is the difference between the amount of freight that they would have earned and the amount which they in fact earned. This loss is, in my opinion, on the facts of this case, recoverable as damages for the breach of contract to load at the agreed rate. So, his conclusion stems from his conclusion that there is only one breach because of the fact that the obligation to load the full and complete cargo was only an obligation to load a winter cargo. That meant that the only breach remaining was the failure to load in due time, but the loss which flowed from that failure to load in due time was precisely the same loss under this heading as flowed from the separate breach that the other two members of the Court of Appeal held was committed by failing to load a full and complete cargo, that being, as Mr. Justice Greer had put it, the primary obligation to load a full and complete cargo. Then he goes on to say, at one time I was inclined to think that where parties had agreed a demurrage rate, the contract should be construed as one fixing the rate of damages for any breach of the obligation. On further consideration, I do not think that this view is sound. I can find no authority on the point, and it's noticeable that in the Saxon ship against Union Steamship Company it was not suggested that the claim for demurrage excluded the additional claim for special damage arising from the detention of the vessel. So that was Lord Justice Banks, upon whose judgment the learned judge really founds his judgment in this case.
So he's clearly against you, but you say wrong.
Yes.
So the key passage there is that last paragraph where he says he thought about whether demurrage was everything that he thinks it is.
Well, it's not, I would submit that that's not the key passage, my lord. What I would submit is that the key passage, and certainly this has always been regarded as the key passage, is that firstly, he assumes that there's only one breach.
Yes.
Secondly, although there is only one breach, he holds that there are two different losses which flow from that breach.
Yes.
One being the loss of freight, and the other being the loss of time.
Yes.
Thirdly, he holds that the loss of freight is recoverable in addition to the loss of time, and that the demurrage provision does not exclude the claim for loss of freight. So that's his approach.
But in a sense, it's that last point that is the key one. The demurrage claim doesn't exclude the claim for loss of freight.
It's certainly right, my lord, that he's effectively saying, well, I was tempted to find the other way, and now actually I've concluded that I shouldn't find the other way. But the reason is because he has held that the loss of freight is one which is of a different character to the pure loss of time.
Yeah.
Whereas when one turns to Lord Justice Atkin's judgment, then going to the sidelined passage.
Unfortunately, the electronic version doesn't have any sidelining.
I beg your pardon, my lord. It's page 363, and it's about 10 lines from the top of the page, beginning, in my opinion, our decision should be for the ship owner.
Got it, thank you.
The result of the authorities appears to be that in a contract fixing a number of lay days and providing for days at demurrage thereafter, the charterer enters into a binding obligation to load a complete cargo within the lay days, subject to any default by the ship owner or to the operation of any exceptions, matters which do not arise in this case. If the lay days expire without a full cargo having been loaded, the charterer has broken his contract. The provisions as to demurrage quantify the damages not for the complete breach, but only such damages as arise from the detention of the vessel. And the important word in that sentence, my lords, is the complete breach. Then he goes on to say, for correlative to the ship's right to receive the agreed damages is the charterer's right to detain the ship for the purpose of enabling him, if possible, to perform his broken contract and to mitigate any further damage. If, however, for reasons other than the ship owner's breach, the charterer becomes unable to do that which he contracted to do, namely put a full and complete cargo on board during the fixed lay days, the breach is never repaired, the damages are not completely mitigated, and the ship owner may recover the loss that he has incurred, in addition to his liquidated demurrage or his unliquidated damages for detention. It appears to me to be incorrect to say that days on demurrage are extended lay days, unless the contract is so withdrawn. On the contrary, demurrage days are days in which the charterer is in breach. And he goes on to consider the different point that had been raised namely the one to which I've already referred, the question of whether demurrage is simply rent for the vessel as opposed to being damages. So he is, as has been put in the cases, a two-breach man. And
Where'd you get that from?
because, my lord, he, firstly from the word complete breach, which is in apposition to only such damages as arise from the detention of the vessel, and secondly from his discussion of potential mitigation of the breach. That's to say that it may be that the charterer can load a full and complete cargo, i.e. as much cargo as he could have loaded within the lay days, within an extended period, in which case then there will no longer be a breach of the obligation to load a full and complete cargo, but there will still be a breach of the obligation within the lay days. So there are therefore...
So you say that the complete breach should be read as meaning both breaches?
Quite. And then
what's the distinction he's drawing between, well, what does he mean by such damages as arise from the detention of the vessel?
Well, in my submission,
because that seems to be his view of what demurrage is about, so
yes.
It'd be quite nice to know what he means by that.
Well, in my submission, what he means is that the damages which arise from the simple delay to the vessel, as opposed to those which arise from the breach of an independent obligation, are covered by demurrage. Is that what demurrage is there for? Is to cover all damages which flow from the delay. But where there is an independent obligation, such as in this case the obligation to load in full and complete cargo, demurrage is not to cover that independent obligation. It is to cover purely and simply the breach in detaining the vessel, not the breach in not loading enough cargo, which is a separate and independent breach. On the facts of this case, the two were interconnected, because it was the delay in loading the vessel which led to the inability to load a full and complete cargo. But if, for example, the position had been that there hadn't been a problem with summer lines and winter lines, and so the charterer could actually have loaded the full quantity of cargo, albeit that it took the charterer longer to do that, then the charterer would have had to pay demurrage, but there wouldn't have ever been a breach of the obligation to load a full and complete cargo. In addition, if in fact the vessel hadn't been bound to the United Kingdom, then it was because it was going to Manchester, I think it was, that the regulations meant that she couldn't be loaded to below her winter load lines, and it was because the parties knew that she was going to Manchester that in turn meant that the charterers could not load the full cargo.
Yes, I mean, another view of this, and it's all quite obscure, might be that damages arising from the detention of the vessel refers to the loss of opportunity to earn freight on the next voyage and the extra period of running costs incurred. Is that a viable interpretation?
It is, but on the facts of this case, then the important point in my submission is that the reason why damages over and above those damages were recovered was because of the fact that there was an independent breach in failing to load the full and complete cargo. And obviously the difference between that breach and that case and our case is that here there is no separate or independent breach by charterers over and above detaining the vessel. And then Lord Justice Sargent was clearer still, and his relevant...
Who did he agree with, do you say?
He agreed with Lord Justice Atkin. and actually he agreed most clearly with Mr. Justice Greer, i.e. two obligations, the primary obligation being the obligation to load a full and complete cargo, with a further obligation being the obligation to load within the relevant period, and the obligation to load within the relevant period provided compensation for the delay to the vessel, but didn't provide compensation for the loss flowing from the separate breach in failing to provide the full and complete cargo. That's to be found in the bundle at pages 49 to 50.
And that's what you say, Lord Justice Sergeant. I'm sorry, that's what you say Lord Justice Atkin has said.
Yes.
But you have to construe him a bit, but with Sergeant you don't.
That's right, but in general terms, as your lordships will see, then that's the way that Lord Justice Atkin has been construed in later cases. The only case in which he's been construed differently is the decision of Mr. Justice Webster in the Altus. And the judge himself in this case construed Lord Justice Atkin as a two-breach man, and he was construed also as a two-breach man in Swiss Atlantique by Mr. Justice McAtter, whose judgment, of course, was upheld by the Court of Appeal and the House of Lords. We can see that, if your lordship go to tab 12, and I'm going to try and take Swiss Atlantique as rapidly as possible.
I mean, I'm sorry, just to stand back from it for a minute, but there does seem to be an understanding in this case, which I think is what is said against you, that demurrage is not a liquidated damages clause for everything, all loss caused by delay. I mean, even though you can drill down with the benefit of hindsight into the one breach, two breach analysis, the truth is there's such an interconnection between the failure to load at an appropriate rate and the failure to load a full cargo that you could be forgiven for thinking there is an apprehension here by these judges, who are in some quite experienced judges, that this is actually, demurrage is not full compensation for delay of all kinds.
Well, my lord, only I would respectfully submit on the facts of that particular case, because of the fact that it was the delay which in turn led to the inability to load the full and complete cargo. Test it this way: if the position is that a charterer simply didn't load a full and complete cargo, and then also delayed the vessel beyond her lay days, it couldn't possibly be said that the owner was not entitled to claim both dead freight for the failure to load the full and complete cargo and demurrage for the detention of his vessel. So
no, I see the point. I mean, I'm perhaps I'm eliding the two due to ignorance, because the reality is the claim for failure to load a full cargo is the dead weight, the loss of freight, which is significant and really not to do with delay. I mean,
yes,
they could have. Yeah. Okay, I get it.
So, my lord, Swiss Atlantique, as briefly as possible, your lordships will be familiar with the facts of Swiss Atlantique, contract for a series of consecutive voyages, and The earlier voyages took too long, it was said. The vessel was detained during the course of those earlier voyages. As a result of that, the vessel could not perform as many voyages as she should have been able to perform. The owners then claimed that they were entitled to compensation for the loss of the freight that they would have earned on the voyages that they should, they said, have been able to perform had the earlier voyages been performed in a timely fashion. And in support of that submission, they sought to rely upon Reader and Argos on the footing that, just as there was a separate loss in Reader and Argos because of the loss of the full and complete cargo, so it was said that there was a separate loss in this case because of the fact that they were not merely deprived of the use of their ship during the course of the periods that the ship was on demurrage, they were also deprived of the ability to earn freight during the period when other voyages should have been performed. Now, one answer to that which the court gave was, well, you should have agreed a higher demurrage rate. But for present purposes, the relevance is if one goes in the report, this is at page 128 of the bundle, then in the left-hand column, then Mr. Justice McAtter says that the reasoning of the three Lords Justices can be concisely stated as follows. Damages were held recoverable by Lord Justice Banks as damages for failure to load in the agreed time, by Lord Justice Atkin as damages for failure to load a full and complete cargo in the agreed time, and Lord Justice Sargent as damages for failure to load a full and complete cargo. The reasoning of Mr. Justice Greer had been similar to that of Lord Justice Sargent. Bear in mind, of course, that the claim in Reader and Argos was the difference in the cargo amount, the difference between the 850 and 544 standards. Then actually, Mr. Justice McAtter goes on to say that the judgments were unanimous to the effect that the charterer breaks his contract by not discharging the ship within the lay days. And then he said the further question that had to be answered in the case was whether the liquidated damages payable under a claim of demurrage were on the fact an exclusive remedy. Lord Justice Banks said if the plaintiff's claim was in substance, though not in form, a claim for detention, the special damage here claimed for would not be recoverable. While at 363, Lord Justice Atkin said that the provisions as to demurrage quantified the damages arising from the detention of the vessel. Again, at 366, Lord Justice Sargent said that the demurrage provision merely assessed damages for any detention of the vessel due to a failure to load at the prescribed rates. These statements are naturally relied upon by the charterers here. So pausing there, my lord, then we would say that this is a claim, in our case, damages for detention of the vessel. That's the breach. And that those passages that Mr. Justice McAtter there cites make clear that the remedy for detention of the vessel is demurrage, and other special damages will not be recoverable over and above demurrage.
Isn't it also quite important to see what he says at the foot of 174 right-hand column? As Mr. Justice Devlin said in Chandris, a demurrage clause is presumably the party's estimate of the loss of prospective freight which the owner is likely to suffer if his ship is detained beyond the lay days. And that seems to be setting out the understanding of two very experienced shipping judges, Mr. Justice Devlin and Mr. Justice McAtter, as to what demurrage is there to do. And it's limited.
Well, except for the fact that if one goes on to the edition of Scruton, yeah, that is there quoted, for which Mr. Justice Catter was responsible. He says, demurrage in its strict meaning is a sum agreed by the charterer to be paid as liquidated damages for delay beyond a stipulated time for loading or unloading. No limitation as to the types of loss which are intended to be covered by demurrage. What Mr. Justice McAtter, in his capacity as editor of Scruton, was saying is that demurrage is a sum agreed to be paid as liquidated damages for delay beyond a stipulated period. No distinction between different types of damages due to that delay. And that statement in that form remained in Scruton during the entire period that Mr. Justice McAtter was editor. At 177, then Mr. Justice McAtter turned to consideration of the fourth.
I mean, just help me with this. I mean, he's using the term "sum agreed by the charterer to be paid as liquidated damages for delay." Obviously, you can have liquidated damages which are liquidated only for particular kinds of loss.
Yes.
Even if they're liquidated damages for delay. So it's, I mean, although obviously you're right at first sight, it is possible to qualify it further, even if they're properly regarded as liquidated damages. So simply highlighting dicta that say demurrage is liquidated damages doesn't answer the question.
It doesn't, but again, I go back to where I started, my lord, which is to ask, well, if it's a liquidated damages provision, and it's providing for liquidated damages in relation to a particular breach, viz. Delay to the vessel, then, normally speaking, liquidated damages in respect of a particular breach cover all damages which are the consequences of that breach, unless there is a statement to the contrary.
Yes, but he said before that it was presumably the party's estimate of loss of prospective freight.
Yes, that's Mr. Justice Devlin in the Chandris.
He doesn't disagree.
No, but again, there's a distinction with respect, my lord, between the manner in which the relevant sum is to be calculated and the primary loss which is anticipated by the parties as resulting from the particular breach, and the question of whether or not the remedy that the parties agree upon, viz. Liquidated damages, is only intended to cover that particular loss, as opposed to leaving at large all other types of loss, which may be very large and entirely unforeseeable, or at least bringing into play, if you like, in those circumstances, all of the difficulties relating to foreseeability, causation, mitigation, all of those things which in general terms commercial parties are trying to avoid by agreeing a liquidated damages clause. Essentially, one is then actually trying to read into a liquidated damages clause a limitation by reference to the type of loss which will most regularly be foreseen by the parties, so as to mean that all other types of loss remain recoverable, notwithstanding the practical undesirability of that being the case.
I mean, might it be said, well, you said a moment ago that there could be very large additional claims. Might it be said that the parties wouldn't be particularly likely to intend to exclude the potential liability for those very large sums by reference to the much smaller sums that they were taking into account when fixing demurrage?
Well, I would submit no. My submission would be exactly the opposite. So, as an example, in one of the cases that we've referred to, Your Lordship, then the parties agreed liquidated damages of nil, notwithstanding the fact that there were hundreds of thousands of pounds worth of loss. In the context of a construction contract, for example, if there are weeks and weeks of a delay, then that will lead to very substantial losses. But nevertheless, the parties agree that in order to ensure that the risk is allocated in a way which they can both provide for and foresee and insure in respect of, they agree the liquidated damages clause in order to allocate that risk.
Here, if you're right, the parties have provided for liquidated damages of nil for all losses other than estimate of the loss of prospective freight, because they haven't, as one might have thought they would if they wanted to cover not only that but any other kinds of loss, added something on top of their estimate of the prospective freight losses.
Well, my Lord, with respect, no, because as has also been said on a number of occasions, then a demurrage rate may overcompensate or undercompensate owners. Market rates vary, demurrage rates don't. And so again, the rate actually may be beneficial to owners. It's certainly been said to be in Swiss Atlantique itself for the benefit of both parties. And it is for the benefit of both parties for the reasons I've already given, namely that it produces certainty. It's certainly right that on my construction, then on any view, then there are other potential losses that a party may suffer, which will not be catered for by the liquidated damages provision. But that's because any liquidated damages provision essentially leads to the result that claims may come into being which one party is left bearing and cannot pass on to the other party. That's simply the consequence of agreeing that provision.
But if we think of liquidated damages as a genuine pre-estimate of the loss suffered from the breach, I'm not sure if we're still allowed to use that formula, but it was current at the time of Mr. Justice Devlin and Swiss Atlantique.
Yes.
Then if what Mr. Justice Devlin says is right, then demurrage is only a genuine pre-estimate of some of the losses which may be suffered.
Well, the genuine pre-estimate of loss is in the language used in the context of penalty clauses. And so it is simply saying that if the clause is not a genuine pre-estimate of loss, it will be struck down. What it doesn't mean is that the clause only covers those things which parties would, generally speaking, anticipate as being the most likely result of the breach in question. Liquidated damages clauses generally apply across the board. They exclude all losses. And again, if one asks, well, why should that be? One comes back to the desirability of certainty as far as the parties are concerned. One comes back in a case like the current one of the result of the judge's construction, which is that not only are you back dealing with questions of causation, remoteness, mitigation for all issues other than damages for loss of profitability, but you've also got the further uncertainty in trying to determine what is outside the demurrage regime and what is within the demurrage regime. This comes back to my Lord Justice Voss's point earlier on. What types of loss are actually then catered for by demurrage? What about hull fouling? What about extra port dues? What about the tornado example?
Why are we assuming
that demurrage is always calculated by reference to the party's estimate of the loss of prospective freight that the owner is likely to suffer if his ship is detained beyond the lay days. I mean, is that a given that everybody accepts, or is it simply a commercial negotiation in every case?
Well, the answer, my lord, is it's commercial negotiation in every case.
And as you say, freight rates change, and demurrage rates don't.
Yes.
So
well,
it may go. The market can go up and down, as they say.
yes, and sometimes then parties will agree a lower rate of demurrage or freight because of the parts of the world that the vessel is being sent to. Because the vessel is being sent to a place where she can expect to earn higher rates of hire or freight or whatever. And so the owner will accept a lower rate in relation to voyage number 1 because he's going to be in a better place for voyage number 2. But as your lordship rightly says, the fundamental point is that the parties are negotiating a conventional sum. They're agreeing a set sum. In the same way as in any other field, the parties are agreeing a set payment as the consequence of a particular type of breach. And I come back to my point that in those circumstances, the parties then know where they stand. And they can make arrangements accordingly to cater for the risks that that are left. And they do make arrangements accordingly to cater for the risks that are left.
But the underlying, the reason I asked that question is that my Lord Justice Mayall's question assumed that was the way demurrage rates are always calculated, and therefore demurrage rates making a genuine pre-estimate of loss caused by the loss of freight, but not by the loss caused by anything else. So that is indicative of the fact that they may not cover the loss caused by anything else.
Yes, well, Lord Justice Mayall's was putting to me the statement in Mr. Justice Devlin's,
Right.
which was his presumption as to how demurrage was in fact calculated.
But and your answer is that, well, he may be wrong about that.
He may.
But I mean, that must be. Before I asked the question, everybody seemed to be assuming that he was right about that. Broadly, that is what demurrage rates are calculated on the basis of. Is that right?
Well, Lord, as I said earlier on, I think
it changes, but
it's fair to say that the principal consideration that the parties will be looking to in agreeing a demurrage rate will be the anticipated profitability of the vessel. Their anticipation may or may not be correct, and as your lordship rightly points out, then whether the owners can get as much as they think that they will be able to earn with their vessel, whether charterers will be willing to pay as much as owners think that they would be willing to earn with their vessel, is another matter. It's a matter of commercial negotiations and commercial strength. However, again, in a sense, none of this answers the fundamental question that your lordship's put to me, which is, well, why should one assume that the parties are not intending to cater for only this type of loss by agreeing a demurrage rate?
I quite follow that point. But as a practical matter, if you're trying to pre-estimate loss, in the average case, presumably you simply are going to do it by reference to the prospective loss of freight, because you won't anticipate as part of your pre-estimate that there are all these other things that could come in.
That's true to an extent, my lord, but again, it comes back to laying off risk in different ways. Because as part of your calculation, you'll be saying to yourself, if you're an owner, you'll be saying to yourself, well, looking at it I'm going to need to pay my insurance premium to my club, or my calls to my club, in order to cater against the possibility that cargo claims are made against me. Whether they're cargo claims that I'm at fault in relation to, and in most cases that will have to be the case, because in most cases if the ship is not at fault, then the ship will not be responsible for the cargo claims. And because, as your lordship know, then most charter parties, probably all charter parties practically, will include the Hague or Hague-Visby rules. Those include the duties placed upon ship owners to take proper care of the cargo within their custody. One of the peculiarities about this case is the fact that one of the assumed facts is that there was a cargo claim which arose notwithstanding the fact that there was no breach of contract on the part of the owners. And nevertheless, that cargo claim was reasonably settled for $1.1 million. Now, one knows as a matter of practicality that that sort of thing does happen. But again, what does one actually cater, or how does one cater for that possibility? The answer in general terms is you take out insurance to protect you against that sort of claim. And all ship owners will have that insurance. Part of the cost of doing business covered by the freight that ship owners earn and the demurrage that they will be the cost of paying for those insurance premiums. So it is, in my respectful submission, artificial to say, well, one should ignore the commercial realities of life in this regard, in circumstances in which the parties have, in their contract, agreed an allocation of risk, which is a perfectly sensible and commercially justifiable allocation.
I suppose you'd expect the cost of the insurance to feed through into the rate at which freight was fixed.
Yes.
I mean, it's a cost of the ship owner, therefore he's going to factor it into what he arrives at by his commercial negotiation as to freight.
Yes. And he won't always be able to get what he's asking.
No.
It will depend on the market. But yes, and it is the case, as I understand it, that in order to go to certain jurisdictions, owners may insist upon higher rates of freight. And one of the aspects that they will bear in mind in relation to those jurisdictions is they will bear in mind the risks that the ship is exposed to by reason of going to those jurisdictions. All sorts of risks. I mean, some risks will be war risks, some risks will be weather-related risks, other risks will be risk related to cargo claims. My lords, I'd like to move on. I'm conscious of the time. I wasn't going to take up time on Swiss Atlantique. Your lordships have got the references to the passages in Swiss Atlantique. But what I would submit is that it is clear from the decisions, in particular in the Court of Appeal, that, perhaps I should just show your lordships this very briefly, page 136 of the bundle, where Lord Justice Sellers indicated that the third proposition was that demurrage, sorry, this is the left-hand column, my lord, in the penultimate paragraph. The third proposition was that demurrage is not an exclusive remedy for a breach of the laytime provisions. It is so only where the claim is for what was described as mere detention. That proposition requires further consideration, which I'll postpone until later. And then if we go over to to the right-hand column, about halfway down the first full paragraph. The frequency of such delays has long resulted in provision for a rate of demurrage, which is an agreed sum to be paid for the detention of vessels over the lay days. No doubt demurrage is based upon a rough and agreed estimation of the owner's loss through the vessel not being able to earn freight elsewhere. There is a passage to that effect in the judgment of Lord Devlin, then Mr. Justice Devlin, which has been cited from Chandris and as Ransom Muller. And then halfway through the next paragraph, the learned Lord Justice says, it cannot, I think, be said that any breach of contract has been established except the failure on all but the first two occasions to load and discharge within the laytime. I can find no other contractual obligation expressed or to be implied. That means that there was delay only and that the vessel was detained. The remedy for that delay is the liquidated damages which have been agreed and fixed by the demurrage rate. So he was finding, firstly, only breach was detention. Secondly, only remedy for detention was demurrage. And they went on to consider Reader and Arcos.
But he's also endorsing Mr. Justice Devlin's view of what demurrage is for,
Yes.
as does Lord Justice Diplock, at the foot of 540 right-hand column.
Yes.
So
I accept that, Lord, but again, what I would submit is that the mere fact that, and I'm repeating myself, so try to avoid doing so, the mere fact that that is how you go about calculating it, because it is the most likely result of detention, doesn't mean that you're not intending to exclude other losses which are the result of detention. And I would submit that the passage that I've just read indicates that a demurrage clause does exclude other losses, because if the only breach is detention, the only remedy is demurrage. Then they discuss Reader and Arcos, and that's at pages in the bundle 137. And perhaps rather than taking up time with that, if I go to Lord Justice Harman briefly, at the end of page 138 of the bundle, he says the breach did consist in taking longer. This is on the left-hand column, halfway down the last paragraph. The breach did consist in taking longer, not on the voyage, but on discharging the cargo, on loading the cargo on each of the voyages except the first. That is the only breach. It is a breach of detention. For breaches of that kind, the parties have entered into a conventional figure for damage, which is called demurrage. That being so, there is no room for saying that damages are at large. The parties have agreed that they should not be at large, but should be, in order to make it easier to assess them, a conventional figure. I cannot see how you can stretch this bargain any further than that. That is the bargain which the parties have made. It may be a bad one. It is not one that the court can mend. And then Lord Justice Diplock deals with the point at the bottom of 138. And at 139 he deals with Reader and Arcos, and effectively says that Reader and Arcos cannot help the claimant in Swiss Atlantique. And this passage is relied upon by the respondents, understandably, and I think is probably the passage that my Lord Justice Mayles was just putting to me.
Sorry, which passage?
This is the passage at 139 on the right-hand column, first full paragraph.
Does not seem to me.
That's right. And the point that's relied upon is that what is said to be the consequence of the detention is that the vessel was detained and could not earn freight, could not be used as a freight-earning instrument, and that is all.
actually, what I had in mind was the page 540 right-hand column, where he says, Lord Justice Diplock says that the nature of the damage of which the parties have estimated the quantum in their agreed sum for demurrage is that during the period of detention the vessel is unable to earn freight. But it's the same point.
It's the same point, yes. Thank you very much. And then in the House of Lords, your Lordships have the references in the House of Lords. The House of Lords dealt with the point somewhat cursorily. Viscount Dillon dealt with the point in about 5 lines. He pointed to the lack of a separate breach.
Which page?
It is in the bundle. At 169. At the bottom of the page. See at the last line, if in this case the appellant has been able to establish a breach of the charter party other than by the detention of the vessel, then Reader and Arcos's authority for saying the damages obtainable would not be limited to demurrage payments. In my opinion, they have not done so. So he treats Reader and Arcos as authority for the separate breach proposition. At 176, Lord Reed simply agreed with the decision, for reasons given by the other members of the House. And Hodson dealt with the point at 187. And going over to 188, he again draws attention to the fact that in Reader and Arcos there was a breach separate from, although arising from the same circumstances as the delay. And it was in these circumstances that damages were awarded. Then Lord Upjohn deals with it at page 197 of the bundle, at the bottom of 197. He says, as both Mr. Justice McCatter and the Court of Appeal held, there was only one breach by the charterers, namely a breach of the obligation to load and discharge at a agreed rate. The detention of the ship in a port beyond that date was a breach of contract for which the parties had agreed damages. The owners, however, placed much reliance upon the case of Reader and Arcos, but with all respect to the argument, that was a very different case. In the view of Mr. Justice Greer at first instance and the majority of the Court of Appeal, there were in that case breaches of 2 quite independent obligations. One was demurrage for detention, as here. The other was a failure to load a full and complete cargo, which had become impossible owing to the onset of winter conditions, and therefore entirely different considerations applied to that case. It is true that Lord Justice Banks reached the same result by a different route on the particular facts of that case, but as Mr. Justice McCatter in the Court of Appeal, with whose judgments I am in full agreement, pointed out, his ratio de sedendi does not assist the owners in this quite different case. Accordingly, in my opinion, that case does not help your Lordship. And then, lastly, Lord Wilberforce, again, simply agreed with the reasons given by Mr. Justice McCatter and the Court of Appeal, and that is page 209 of the bundle. Lords, if I then take your Lordships again briefly to the case of the Altus. This was the case I mentioned earlier on, in which Mr. Justice Webster decided that dead freight and enhanced demurrage could both be recovered. And his discussion of the point begins at page 242 of the bundle. I can, though, deal with it briefly, I hope. So, as he says, actually, just after the quotation from Chandris and Isbranson Moller, he says, in Reader and Arcos, the Court of Appeal certainly, it seems, treated a demurrage clause in the same way, liquidated damages for a certain type of breach. It does not seem to me that the dead freight clause is necessarily to be treated in the same way as a liquidated damages clause, and if it should not be so treated, which I do not purport to decide, that would be the end of the defendant's case on this point. If I can ask your lordships then just to turn forward a few pages to page 246 in the bundle. In the second full paragraph, he sets out his conclusion, where he says that the defendant's defence to the plaintiff's claim for damages fails either because the dead freight clause is not a liquidated damages clause at all, or because if it is such a clause, the point raised by their defence has been decided adversely to them by the Court of Appeal in Reader and Arcos. Now, the point in this case was that there was a dead freight claim, and the dead freight had been paid. In addition, there was a claim for superadded demurrage because the demurrage rate applicable would have been greater had the full amount of cargo been loaded. And at 243, having set out some passages from Chandris as Isbranson Moller, then he says that it seems from those two passages, therefore, that Mr. Justice Devlin treated the decision in the Court of Appeal in Reader and Arcos as one which decided that damages for a breach of the obligation to provide cargo were recoverable, in addition to the damages recoverable under the demurrage clause, if that breach, i.e. the breach of the obligation to provide cargo, gave rise to damages of a different character. Then he says the textbooks, however, interpret or seem to interpret that decision differently. In fact, when one looks at the quotations in the textbooks, they don't, with great respect to the learned judge, interpret the decision differently from the way in which he had just interpreted it. So McGregor, citing Reader and Arcos, again refers to the ability to recover damages if other breaches have occurred outside those which fall within the ambit of the liquidated damages provision. And Scrutton, 19th edition, says the delay may give rise to breaches of further obligations, e.g. to load a full and complete cargo for which damages are recoverable in addition to demurrage, as in Reader and Arcos. Then actually it goes on to say, because there was only one breach in the current case, i.e. not loading enough cargo, it's necessary to examine the judgment of the Court of Appeal in Reader and Arcos with some care. And he then went on to do that and concluded that Lord Justice Atkin was a one-breach man rather than a two-breach man, and that accordingly, even where there was only one breach, that did not preclude recovery of a different head of loss, which was the question where he had set for himself. In fact, however, then in holding that Lord Justice Atkin was a one-breach man, he, with great respect, I would submit, fell into error, because Lord Justice Atkin was, as I have sought to demonstrate, your lordships, in fact a two-breach man, and was in agreement with Lord Justice Sargent and Mr. Justice Greer in that regard. The major importance of the ALTUS is simply because of the fact that it has been relied upon by the textbooks as authority for the proposition that where you do have one breach, different sorts of loss, nevertheless then a claimant can recover in respect of both of those sorts of losses. But it's for various reasons not good authority for, or not reliable authority for that proposition. Firstly, because of the fact that Mr. Justice Webster was proceeding on the hypothesis, which he indicated at the end of his judgment he thought was a false hypothesis, that a dead freight clause was a liquidated damages clause. And secondly, because he, with great respect, misconstrued the decision in Reader and Arcos, and he also misconstrued the various textbooks. Now, the learned judge, Mr. Justice Baker, and I are ad idem in relation to the fact that this judgment of Mr. Justice Webster is not a reliable judgment and should not be relied upon. Next judgment, very briefly, is the Adelpha. That is at the next. That is at tab 22, page 314 of the bundle. And here, then, Mr. Justice Evans, as he then was dealing with the question of whether the receiving ometer, none of this was necessary to his decision. But he actually then did indicate that this is in the left-hand column, about 10 lines from the bottom. It says, when such further loss does exist.
The left-hand column of which page?
It is at page 314, my lord.
Thank you.
I apologise.
Mm-hmm.
When such further loss does exist, then I'm prepared to assume in the plaintiff's favour that a damages claim may succeed. Three distinguished judges in Reader and Arcos gave differing reasons for their decision that damages were recoverable in addition to demurrage in the circumstances of that case. One view is that damages were awarded for a breach of contract other than the failure to complete loading within the lay days, namely the failure to load a full and complete cargo. But even on that basis, the amount of cargo which the charterers were required to load has to be measured by reference to the time when the lay days expired, rather than later when the vessel sailed. So he's there, as it were, recording agreement with the approach of the majority to the question of the correct quantity of cargo, contrary to the view that Lord Justice Banks took. The view that damages are recoverable in addition to demurrage for the single comprehensive breach is supported by the judgments of Mr. Justice Devlin, as he then was in Chandra's, and by Mr. Justice Webster in the Altus. Authoritative statements of the law are found in Swiss Atlantique, likewise in the judgments of Mr. Justice McAtter at the Court of Appeal in that case, but these, in my respectful view, do not necessarily preclude the submission on behalf of ship owners that an independent head of damages may be recovered in the circumstances of a particular case, but those circumstances do not arise here. So it's not a case that is of great assistance to your lordships. Then, my lords, lastly we come to the decision in the bond, which is at tab 26. And in brief, Mr. Justice Potter, as he then was, set out having set out the facts of Reader and Arcos, went at the bottom of page 382 of the bundle to note that, having recorded Lord Justice Banks's view that there had been a breach of a single obligation, and Lord Justice Sargent's view that there had been two breaches of two separate obligations, he then said that the judgment of Lord Justice Atkin provides some difficulties as a matter of analysis. Mr. Havelock Allen would align him with the judgment of Lord Justice Banks as having allowed the recovery for two types of damage for a single breach. Mr. Wood seeks to put him with Lord Justice Sargent. In my view, while the matter is far from easy, Lord Justice Atkin is properly to be regarded as a two-breach man. At page 516, the breach identified him as giving rise to the owner's right to recover was the Charterer's failure to complete the loading of the ship within the lay days. So identified, that breach was not ipso facto one which entitled the owners to recover demurrage. It is not the failure to load a complete cargo which gives rise to the right demurrage, it is the subsequent detention of the vessel at the loading port. This was implicitly recognised by Lord Justice Atkin later in his judgment. And then he said the phrase which has given rise to the difficulty, and which taken alone might seem to suggest that Lord Justice Atkin is to be regarded as a one-breach man, is his remark that the provisions as to demurrage quantify the damages not for the complete breach, but only such damages as arise from the detention of the vessel. In my opinion, viewed in context, those words were used as no more than a shorthand method of referring to the entirety of the Charterer's breaches, namely 1, failure to load a complete cargo by the expiry of the laytime, and 2, subsequent detaining of the vessel in port. I am fortified in this view by the fact that in the case of Swiss Atlantique in the Court of Appeal, Lord Justice Sellers, with whom Lord Justice Harman and Lord Justice Diplock agreed, considered that the judgment of Lord Justice Atkin was to the effect that the damages recovered for dead freight were for a different, separate breach of contract and wholly independent of the detention of the vessel, though it was, of course, the delay beyond the lay days that created the inability to perform the other aspect of the obligation, which was to load a full and complete cargo. He then considered the altus, and he concluded that, in particular, because of the fact that Mr. Justice Webster had not been referred to the Swiss Atlantique cases, that his judgment was not one which should be followed, and he referred to the Adelpha, but said that in view of the fact that the expression of view in that case was both obiter and in somewhat tentative terms, that did not dissuade him from the view that he had himself reached, namely that it was necessary to show an independent breach in order to recover damages over and above demurrage. He then actually deals with a submission to the effect that because this was a sale contract case, then that somehow gives rise to a difference, and rejects that submission. Well, that is the case law as it stood at the time that the matter came before the learned judge. And I would submit that, in summary, the position is, firstly, that the better view of Reader and Arcos is that it turned upon the existence of two independent breaches. Secondly, that view of Reader and Arcos was supported by the decisions of the courts in the Swiss Atlantique case, and in particular the decisions of the Court of Appeal endorsed by the House of Lords, and that the decision in the Altus and the dicta dictum in the Adelpha are not particularly reliable for the reasons I have given. In those circumstances, then the decision of Mr. Justice Potter, which was reached after a full consideration of the authorities and full argument, was, in my submission, a good decision and one which the judge should have followed. As I have noted already, then the decision in the bond has been followed in various other authorities. It was followed in a case called the Luxmar in front of Mr. Justice Langley, in which my Lord Justice Mayles appeared, and it's been followed in London arbitrations since then, without any apparent differences being, without any apparent untoward discussion. Then there are the various textbooks, and I wasn't going to take your Lordship through those in any detail. The earlier views, the earlier editions of Scrutton don't actually express a view one way or the other in relation to the matter that is in issue on this appeal. The first one that does actually express a view clearly is the 1974 edition, and that treats Reader and Arcos as authority for the proposition that damages may be recoverable in addition to demurrage where there is a separate breach over and above detention of the vessel. That remained the case in Scrutton from 1974 through until 1996. And in 1996, the views of the editors changed, and for the first time, the suggestion was made that the better view was that loss which was different to loss of earnings could be recovered over and above demurrage, even if there was, or loss that was different in kind could be recovered, even if there was only one breach. And as I've indicated, the authorities that were relied upon by the learned authors for that proposition were firstly Reader and Arcos in the judgments of Lord Justice Banks and Lord Justice Atkin, who they clearly therefore regarded as in the same camp, if I can put it like that, i.e. both one breach men. For the reasons I've sought to outline, that is not correct. Lord Justice Atkin was a two-breach man. They rely then upon the Altus, and they rely upon the Adelpha, and your Lordship have my submissions on those cases. Carver, your Lordships have already seen, that regarded the position as settled in the first edition, unsettled by reason of this case in the more recent edition. Voyage charters at tab 66, that regards the bond as the relevant guiding authority. Shipbuilding contracts at tab 47, the same view is taken there. Mr. Gay's 2004 article advocates adopting Lord Justice Banks's approach, but what I would ask your Lordships to read, I'm not going to read it to your Lordships now, is just look at the section of that article that deals with loss of use and types of loss of use, because that does actually illustrate quite clearly how difficult it is to define what is not within the scope of the coverage.
What's the reference to that section, please?
That is in Mr. Gay's article is in tab 48, thank you very much, and the section of the article in question where he deals with the is at 659. Well, that begins at 658, where he deals with what a separate type of loss is.
Thank you.
Proffers, in a sense, the suggestion that it's a matter of intuition.
You say intuition doesn't work in the commercial sphere.
Quite so. I would also say that it's quite likely that charterers' intuition and owners' intuition are unlikely to be the same. Lastly,
did the judge give? I mean, did he address, for example, bottom fouling or other examples, and
No,
say
no.
how you would decide which
No,
side
he-
you felt?
He only addressed himself to the particular facts of this case. So he said that that a cargo claim was clearly a different type of loss from loss of profitable usage of the vessel, but he didn't address, if you like, the more general question that your lordship puts to me. That's to say, what would or wouldn't then come within different types of loss for these purposes.
Thank you.
I see at the top of 662, Mr. Gay attempts to draw a distinction.
One example the judge did give, my lord, I'm reminded, is that he said that port dues would be within demurrage.
Mr. Gay,
No, the judge.
Judge.
But he doesn't explain why port dues would be within demurrage. Obviously, port dues are, in fact, superadded expenditure of prolonged delay in port, as opposed to the loss of profitable earnings. But his rationale was probably that he felt that you had to recognise that you would have to pay port dues out of earnings, and therefore you need to take that into account in the same way as in a case called the Nick Murray. Mr. Justice Paul Biggerson then was held that superadded diesel oil, which was burnt in port, would be within demurrage. But, sorry, my lord.
I'm not sure it matters, Mr. Hancock. I was noticing that at the end of the section you took us to page 662. Mr. Gay suggests a distinction, I think.
Yes. Well, he says, doesn't he, that other people may be able to suggest better distinctions, but one possible one is one that he there identifies. There is then a further article that Mr. Gay produced, which is at tab 49 of the bundle. And when I say he produced it, this is a draft of an article that is due to be published in the Lloyd's Commercial and Maritime Law Quarterly, in which Mr. Gay deals with potential difficulties which may arise if his view, namely that Lord Justice Banks's approach should be adopted, is adopted. And one concrete example of that is clauses which provide for half demurrage. Because then the question has to be, well, let's say you've got a cargo claim and you've got a half demurrage clause. How do you actually determine how much of the cargo claim is ascribable to the period that is, in fact, on demurrage, if the position is that, or part of the period, then the vessel is on half demurrage. Mr. Gay's suggestion is that you prorate the cargo claim so that if the position is that demurrage is payable at half the standard rate during the relevant period, then you would pay half of the cargo claim. And with my respect, that is an unprincipled suggestion, which goes to show the difficulties which are produced by introducing what is quite clearly a non-bright line distinction of the sort that the judge's judgment leads to.
So this is, we're told, a proof copy of a forthcoming article, which is due to be published when?
I understand imminently.
Right. Okay.
But I can't answer your lordships of any
All right.
more exactly than that.
And are you able to point us to the particular bit referring to the half
Yes,
rate?
the half
demurrage?
rate to demurrage. So he deals firstly with the question of impossible obligations, which the construction may lead to. Then he deals with exceptions to demurrage and half rate demurrage at page 678 of the bundle and following.
He writes at some length, Mr. Gay, doesn't he?
He does. He was at the time he wrote the first article, he was a solicitor at Hill Taylor Dickinson. I think he is now a maritime arbitrator.
Right.
He's a supporting member of the LMAA. My lords, then the judge, in relation to these potential difficulties, suggested, this is in paragraph 59.3 of his judgment, suggested that there were various answers to the problems that we have identified. And just to recap very briefly on those, then we dealt with liquidated damages generally. That also promotes cheap and rapid claims handling. In demurrage claims generally, as your lordships will know, then there are usually very short time bar provisions. In the tanker trade in particular, then it's usually a 90-day time limit for the presentation of demurrage documentation in the making of demurrage claims. The clause is actually for the benefit of both parties, as I've indicated. I've indicated the uncertainty problem. And the judge's answer was, he says, well, a demurrage clause is not a limitation clause, but it's not a limitation clause in the sense that it's not an exclusion clause, but it is a limitation clause in the sense that any other liquidated damages or limitation of quantum is a limitation clause. It makes clear that claims other than for the set amounts are excluded. Secondly, he said that Reader and Arcos meant that parties would of necessity have to grapple with what was meant by a different type of loss. But with great respect to him, then, if in fact the question is whether there has been a different and separable breach, the amount of cases in which it will be necessary to grapple with that question is unlikely to be great, as is shown by the fact that there have been so few cases in which this issue has arisen.
Well, a few cases before the court, but presumably quite a few cases in arbitration.
Well, there have certainly been cases in arbitration in which your lordships have examples of, where arbitrators have applied the bond and they've applied the separate breaches approach in the bond. My point is that where the rule is that you have to show a separate, a breach of a separate obligation, then it is likely to be relatively simple to show that breach of a separate obligation. And it's not going to be open to very much doubt. But your Lordship is quite right that the majority of these sorts of disputes will be dealt with in arbitration rather than in court. The judge's approach also promotes a meaning of demurrage, which is difficult to square with the usage of that word in other clauses. So, as I've indicated, then charter parties often contain demurrage time bars. And so what one would be left with in this type of situation is that you would have a time bar clause, let's say 90 days, which applied to claims for loss of profitable use of the vessel, and a claim which was potentially, well, not unlimited, but with a 6-year time bar for cargo claims arising out of detention of the vessel. And in turn, that would militate against sensible and speedy resolution of claims, because the whole point is that one wishes to be able to investigate these matters as rapidly as possible. That's why the time bar provisions are there, and are indeed encouraged by the courts. The point I've also already made is that this all assumes that there hasn't been a breach by the owners, and that is unlikely, in fact, to be the case. And dealing very briefly with the points that are made by owners in paragraphs 76 to 83. As to certainty, they say, well, this is only looking at it from the charterer's perspective. We say, no, it's not. As with any risk allocation provision, it means both parties know where they stand. The second is as to the uncertainty of the dividing line.
So where are you reading?
Sorry.
Where are you reading?
I'm looking at paragraphs 76 to 83, my lord, of the respondent owner's skeleton.
Oh, right, I thought you were looking at the judgment. Sorry.
No, and it may be that it's easier for me to deal with these in reply because I'm conscious of the time.
Well, I think probably that is the best way.
My lord, just lastly on the judge's judgment. The judge's judgment, essentially, there were really 2 points that he took in response to the decision in the bonding. There were two real nubs, the 2 nubs of his argument, if you can have 2 nubs, were that, firstly, the suggestion that the majority in Reader and Arcos were to breach people did not militate against Lord Justice Banks's analysis. They weren't, if you like, inconsistent with one another. And to that I would say, if in fact the other 2 members of the Court of Appeal agree with Lord Justice Banks, they spent a lot of time not saying so. It would have been the easiest thing in the world for the other 2 members of the Court of Appeal to say, if you've got 2 different losses flowing from the breach, then you can recover both losses. Instead of which, then they went out of their way to find that there were 2 different breaches. And the logical inference from that is that they didn't agree with Lord Justice Banks. We know that they didn't agree with Lord Justice Banks in relation to the point my Lord Justice Mayles put to me, that's to say as to the correct quantity of cargo. Because we know that the majority found that the correct quantity of cargo was the summer cargo, not the winter cargo, because the correct quantity had to be judged by reference to when loading should have been completed, not when loading was in fact completed. So I would submit that the judge's reasoning in that regard is unsatisfactory. Secondly, then the judge relied upon the fact that, in his view, Swiss Atlantique did not militate against the owner's case, and that, in his view, then Mr. Justice Potter, when he relied upon the fact that Mr. Justice Webster had not actually had Swiss Atlantique cited to him, had been misled. And when Mr. Justice Potter relied upon what Swiss Atlantique in fact said, Mr. Justice Potter was wrong, because the learned judge's view was that Swiss Atlantique was in fact in favour of owners. I would submit, on any view, Swiss Atlantique is not in favour of owners. In fact, it is clearly in favour of charterers, and that is the clearest example, the clearest proof of that is in the footnotes from Scrutton, to which I've already made reference, where the learned editors, essentially having relied for the proposition that they put forward on the Altus and the Adelpha and the one breach analysis in Reader and Arcos, put forward, by way of comparison, Swiss Atlantique and the bond. So, in their minds, then, you're like, one group, one camp, is represented by one breach, Reader and Arcos, the Adelpha and the Altus, and the opposing camp is represented by Swiss Atlantique and by the bond. The judge, in his judgment, said that Scrutton hadn't referred to the bond. That's actually not fair to Scrutton, because what actually Scrutton refer to is they refer to the case, but by reference to the names of the parties, not by reference to the name of the ship. So they refer to Tertre and Richco, who were the two who were named parties, not the bond. My lords, unless I can be of any further assistance, then those are my submissions.
Well, that's very good. Thank you very much, Mr. Hancock. Mr. Rainey, Mr. Hancock hasn't given you an opportunity to poison our minds before lunch, so you'll have to wait for that until after lunch.
It's very skillfully done, my lord.
It was skillfully done. We'll resume at 2 o'clock.
Court rise. So there's a 90-second delay, so anything you say is still